Welcome, friends, to the initial broadcast of Autonomous and Anonymous. I am the autonomous part, but I'm also going to remain anonymous. There's an anonymous part, and he's also going to remain autonomous. We'd like to introduce you to a friend we'd like to meet ourselves, Mr. Mark T. Harris. Mark T. Harris has been an attorney in the Sacramento area for a very long time. He's got a lot of kudos and credentials under his belt. He teaches at the University of California here in Merced. I'm here in Merced right now, hoping just to get a chance to talk to Mr. Harris. Okay? Unfortunately, the school's batting down the hatches these days, and that's understandable. And getting into his office to talk to a man like Mr. Harris is hard to do. I mean, Mr. Harris was an accomplished lawyer in and of itself. And then what he did was he took his camp and put it under the umbrella of another accomplished lawyer, Ben Crump, and formed a dynamic partnership here. I'm a thinker. I don't need my names up in lights. I just come up with ideas. I sit and ponder puzzles. And so I have a challenge for Mr. Crump and Mr. Harris. I'm in here in Merced. I'd like to talk to Mr. Harris if I could ever get a chance and present these ideas so he could take these ideas and run. And this is what this presentation is about now. So then, I liked what one of the students said about Professor Harris. He said he makes bold politically charged statements and challenge you to say anything different. But then I realized he isn't interested in pushing his agenda. He wants you to form your own position and be able to think for yourself, which is the best kind of learning available. I respect him. Reading that, I can respect that too, because I've always been one to want to think for myself, and I've always disliked it when others tried to think for me. So I can respect that in him, and I feel that this is the right person to take my idea and run with it. And I hope that all of you that are listening to this idea will encourage this duo to take on this challenge that I'm giving them today. Mr. Harris and his firm, they are the voice for the voiceless. But let me ask you, who is the voiceless? In our opinion, the voiceless is anyone that has been given a public defender. It seems now that what has happened is the judges are not upholding defendants' rights. The prosecution is not investigating cases, and we're going to show you evidence on these things. We're not just going to mindlessly tell you, we're going to show you through the fact. And it seems like the public defenders nowadays have the interest of the state more in heart than their clients, and we have evidence on that too. We have a lawsuit that we'd like for Mr. Harris to take up. Oh, it's a very, very interesting one. It's a diversity of citizenship claim. It's where a person in one state is suing a person in another state. So this diversity of citizenship will be against a man that was living in the state of Montana and is suing characters in the state of Tennessee for a conspiracy to obstruct justice and deny his rights and privileges. And that's going to be a very interesting thing. But what I'm here to challenge Mr. Harris and Mr. Crump to do is sue the United States Attorney General's office. Wow, that is a big order, isn't it? To sue the United States Attorney General's office. Why would I want to ask them to do that? Well, sir, because I believe there's a conflict of interest with the public defender system. Because, as I've already mentioned, it seems that these public defenders are upholding the rights of the state over the right of their clients. This is not acceptable behavior. So, gentlemen, I would like to show you how to accomplish this and how to create a public defender system that is really a voice for the voiceless. Now, as you watch, I'm going to show you something that we've all seen before. However, I've changed a few words. I once called it a modified Declaration of Independence, but I now call it a personal Declaration of Independence. What I did was changed necessary for a people. I said one person and a people. This is one of the most significant changes here. We hold these truths self-evident that all humanity is created equal. Now, I want to point out to everyone listening that this is one of the most important lines in the whole Declaration of Independence. That to secure these rights, governments are instituted among men deriving their just powers from the consent of the governed. Mr. Harris, I withdraw my consent. Could you help me withdraw my consent? Because I'm being oppressed, and I can tell you how. Let me continue. That whenever any form of government becomes destructive of these ends, it is right the people to alter or to abolish it. The criminal justice system is out of hand, sir, and it needs help. As you can see at the bottom of my modified version of the Declaration of Independence, I did have the native peoples of North America in mind when I wrote it. However, as it can be seen, it is a personal. And what this declaration is about is showing the government that I am a responsible individual to make these decisions for myself. There's a movement called the sovereign citizen movement. It makes the idea of self-governing look bad. I'm here to show you how that if you can show yourself approved, it actually is a good thing, and it shows how responsible you are. They have this thing called the age of consent in most states, and basically it's stating that, hey, this person reaches a certain age, they're so-called responsible. I think it would be better if there was something like the age of responsibility. You see, you have to actually do acts to show that you're responsible enough to have that responsibility. So when Mr. Harris and Mr. Crump sued the United States Attorney General's office for control of the public defender system, they create a 508c faith-based organization, and the faith is that we believe in liberty and justice for all, and we're darn sure going to make sure everyone gets it. That is our belief. How about yours? Therefore, they can use the 508c to create a faith-based organization to put the public defender system under, and then create a training system to specially train these individuals to be the adversaries the Constitution meant them to be. Because when it's your life and your rights on the line, and when you meet the people who had their lives on the line, you'll understand what it's like to have to put your hands in your life into someone else's hands and trust them. But then they haven't even bothered to take the opportunity to look at the incident reports or interview witnesses or investigate your case. Who wants this? It isn't like on TV. These gentlemen have the power and the resources to do this, and we should encourage them to do this. And I'm going to explain to you how they can. These are the same gentlemen that got Breonna Taylor's family $12 million when that poor woman had her door broken down and was shot. And they also helped the family of George Floyd. I'm asking to help all the rest of us that have no voice. And that's anyone that does not have a dollar to pay for a high dollar lawyer, because someone might have made something up, and I've got somebody that's not even investigating and looking into the veracity of the claims against me. This needs to change. So we start a faith-based organization that trains the lawyers to do it right, to do the right job, to where we have these guys in every courtroom holding the courts and the prosecution accountable to the Constitution like they should. Now then, I believe that I, myself, am my own faith-based organization. Let me explain. See, I have a belief that I live in a world of cause and effect, and that if I mind the cause, the effect will take care of itself. So, according to my belief, I am not going to go out and harm you because I honestly believe if I harm you, I'm going to bring harm to myself because I live in a world of cause and effect. So yes, I have to work my life to live in a manner to where I live it and prove it, and I'm not just lip service. So then, that puts a level of responsibility on me to show that I'm approved. That means I have to study. I have to put forth effort. I have to show that I am responsible enough to have this responsibility of self-governance, to be my own faith-based organization, to allow the government to have less control in my life because it hasn't served me. Now, what I'm fixing to show you is a document from a Native American church. And no, I am not backing any of these organizations. I'm using these organizations, what they put out, as templates to go by. Now, this here document talks about a Ninth Amendment constitutional rights, and it deals with the Native American church providers. But really, you look at this as a template. And what it shows really is it shows that this is more like a contract. It's a Ninth Amendment contract between you and the government saying, look, these are my rights and these are my responsibilities. I have the right to do this as long as I don't do that. And let me tell you folks that this document here is not a toy. If you write down that this is your right and this is your responsibility, you have to back it up with your actions. That's what this Autonomous and Anonymous is all about. It's about showing yourself approved. And I hope that I can get these individuals to take on this task, because if they do, this whole justice system can change. The whole way we do things will change because people will actually have a challenge. They'll put forth effort to show that, hey, I should be able to do this. Look, I'm capable. But you're going to have to be able to show that you're capable. Look, right here under number 3, the right to provide products, regimes, modalities, services. This is not applicable to everybody. It's to these practitioners or these providers. But note it says, I shall not provide any service that I am not qualified to provide based on my authorization, experience, and education. I shall make no false representations about my authorization. See, this is a contract showing your responsibility. Now then, all we need is the men to wrestle the public defender system and help us institute this system to where we can begin to govern ourselves and take more burden off the representatives and make their lives and their jobs easier, because we can show them that we are able to think for ourselves and make responsible decisions. And you must know that if you know I can make responsible decisions for myself, then you know that I'm never going to do anything that's going to harm any of you. And hopefully that my actions will show that. I'm autonomous and anonymous and anonymous, and I thank you for your time. Now let me introduce you to some other friends that have no voice, like me, like you, and like all of us, that have a wonderful public defender, and there's no one investigating your case whatsoever. Thank you, Mr. Harris. Thank you for all your efforts in bringing justice into this world and helping to make this world a better place for people to make their own decisions and to think for themselves. Thank you, sir. Namaste. Greetings. I'd like you to meet Bernie Montgomery, a good friend of mine. I actually got this paperwork directly from him. I don't want you to focus on Bernie as a person, so to speak, and I don't want you to focus on the other individuals named here. It's not a matter of who these people are, nor the color of their skin. The point and purpose of this documentation is to show how law enforcement officials are not properly trained to investigate a situation. First of all, as you can see, there's a lot of blue marking on there. First of all, look up at the top. The individual Bernie was facing life in prison. So you had an investigator that showed up. Bernie was, what does it say? Height, 270 pounds. The woman is, I think, 95 pounds. It's up there. You can read it. Now, on the above date, it says she's coming home from work. She sees him standing at the back of the building, and though she tries to race him to the door, common sense would dictate that she would drive off and phone the police somewhere. This is 2000, so cell phones weren't as prevalent at that point. So her getting out and going to the building and racing him to the door when he's standing at the building is quite a bit skeptical and should have piqued the interest of the investigating officer. But when we look at the words from the investigating officer, we're having really kind of a hard time understanding what he's saying to begin with. But here's where it gets really, really iffy. It claims that Bernie is arguing with this woman, and there's a knock on the door. And she knows who it is, which now it's a chance for her to escape, but she doesn't. And she claims Bernie throws this guy, a 195-pound man, to the floor and runs to the kitchen. Now, interestingly enough, what does he do? He gets a screwdriver, not the biggest butcher knife, this or that, and comes up and holds it to this 95-pound woman's head. This is where we have to stretch credibility because he then says he takes paper, stuck it in her mouth, and duct taped it shut. First and foremost, that he's holding this person with two hands, one hand to hold her from getting away, and one screwdriver to her head. And he's got a 195-pound man to the floor that's ready to pounce, I guess, if he makes a sudden slip. So, which hand did he let go of to use the paper towels and then that duct tape? Me personally, I've never been able to use a roll of duct tape with no hands. How about yourself? However, his lawyer never bothered to read this document very well, and he was forced to have to plead to 10 years instead of having his public defender and challenge the witness on the witness stand by asking her how he happened to use that roll of duct tape with no hands. That is a mystery. Here's where it gets better. You'll see that it notates the second person right here. We won't talk about his name, but you see complainant too, and you'll see a blue mark right there. Now then, as you see down, it starts talking about the duct tape. Now it goes further, and you will see the date changes to 9/25/2000, and it goes on. You'll see as it goes on, Lieutenant White was also advised the victim too that the suspect stabbed him in the hand with the screwdriver when he made attempts to get him away from Miss her. Lieutenant White did observe the laceration in Montgomery's hand. Mr. Montgomery stated that he did wish to file charges on the suspect. By the way, there were two Mr. Montgomerys, but they were not related. So, accordingly, Miss White says that this second complainant was stabbed in the hand that day. But when you go back up to the incident report, Right here it says victim number 2, visible injury, no. Complaint of non-visible injuries, no. So what injury did Leroy show Lieutenant White a month later that was not visible the night that the officer took the report? You see, if this man had a lawyer that had simply read the incident report and investigated his case, he'd have never lost 10 years of his life. He would have not lost that 10 years of his life with his daughter, Enki, and I remember her name quite well. Oh, by the way, Bernie challenged me to read a book called Black Like Me. Have you ever read it? It's quite an interesting book. Maybe y'all should. Uh-huh. Now we'll move on to the next guy. Oh, the next victim of our wonderful judicial system. Welcome to the voiceless. The voiceless is anyone that gets saddled with a wonderful public pretender. This is what needs to be changed. This is how we get justice. This is how we hold the prosecution and the courts accountable, by having defenders that actually give adversarial proceedings and hold them to the letter of the law as they hold you and I to the letter of the law. Continue with me as we journey on, and I show you how it's done. Thank you, and bless me. Here you have a document from the American Bar Association. That's what it says, ABA. In February 1999, the American Bar Association House delegates approved these black letter standards that have been published in the commentary in the American Bar Association Standards for Criminal Justice, Special Function of the Trial Judge, third edition. All right, so then let's go down here. 6.1. The general responsibilities of the trial judge. Ooh, too far. Ooh, just scrolling to, here we go. A, the trial judge has a responsibility for safeguarding both the rights of the accused and the interests of the public in the administration of criminal justice. The adversary nature of the proceeding does not relieve the trial judge of the obligation of raising on his or her initiative at all appropriate times and in appropriate manner matters which may significantly promote or a just determination of the trial. So now, we've talked about Bernie, who you've seen over here, and the lack of investigation, and we've talked about how the system's supposed to work, and here you've seen what the American Bar Association says about the trial judge, but really the trial judges, as you see, in reality, they're upholding the rights of the state over the people. This is why we need Mr. Harris to take on the public defender system and create a faith-based organization out of it. And so let's show Douglas McAlpin, who has a diversity of citizenship for conspiracy to obstruct justice and rights and privileges. See, it's quite a case. See, what's happening is back in 92, Douglas was arrested as a material witness, and that's a fishy situation in itself. The reason being is because the date it was signed was June 25th, 1991. However, the information that's documented on that document that was signed June 25th, 1991, was added the next day on June 26th. And if you go, oh, ooh, looky there. Shoot, these are the exhibits. Check that out. Oh my goodness, we back it up all with proof, don't we? So that's not the one. That's it right there. Mm-hmm. See, it signed right there June 25th. But right here it says on Wednesday, June 26, 1991, I became certain. Now, this was to arrest him as a material witness. What this document does, what this affidavit of complaint does, is it shows that whoever signed this document signed it the day before any of this information was ever put on, because he says on June 26, 1991, I became concerned. Well, how did you become How did you get it signed the day before you got concerned? You see the fishiness here. And he's using what's called hearsay statements. So see, his original arrest as a material witness was fishy. Now, let's just go with the evidence. See, they had gone in and turned his dad in for a killing, but there was nothing implicating him and the woman that turned his dad in. They were free to go. Then on this was done on the 23rd. Then on the 25th, they signed this affidavit. A day later, the information was put on it, and then Douglas was arrested as a material witness. Now, there was no evidence whatsoever implicating Douglas to this crime. Now then, as you can see from the affidavit, this constitutes an illegal arrest. So then, the day before his dad's preliminary hearing, it's claimed by the Robertson County Sheriff's Department that on June 30th, which is the day before his preliminary hearing, that the man was waiting in his cell for the guards with a pointy shower handle and attacked them. And interesting enough, the dad was the only one that got hurt. Later on in an appeal, which is documented in the evidence that's listed for this suit, it's shown that the man claimed that his confession was coerced, and we find out that it is. Because if you look at all these documents and the evidence that is supported with his claim, you'll see that Robertson County Sheriff's Department coerced a confession from Danny McAlpin that implicated both Douglas Scott McAlpin and the woman in his killing when there had been no evidence before. It's obvious and blatant from the evidence what had been done. They knew that Douglas had nobody. They could implicate him, manipulate the law, twist the facts, and have him tried and convicted. Well, technically, he was first indicted as aiding, abetting first-degree murder when there wasn't even really any evidence to that. The most that could have been claimed from what existed would have been aiding, abetting after the fact. However, when this man had gone and finished going to trial, he had been convicted of voluntary manslaughter. And in order to be guilty of voluntary manslaughter, you actually have to participate in the killing. And only through a manipulation of facts did they convince a jury to convict a man for voluntary manslaughter when they had absolutely no evidence to substantiate the charge. Mr. Harris, Douglas McAlpin needs your help. Mr. Harris, I need your help. Mr. Harris, everybody that's going to have a public defender needs your help. Please take up this cause and go forward. Namaste.